So welcome everyone to the final session of the conference, particularly given the nice weather outside. Our topic is the international law of tomorrow, legal innovation and developing fields. My name is Joshua Kelly and I'm the moderator of this panel. I'm a partner in the international law and arbitration team at Freshfields. So we have four speakers with us for the next 90 minutes, and with any luck, we'll have 15 minutes carved out at the end for questions. I'm generally accused of being too much of an optimist, but in circumstances where we spent the last couple of days hearing about the challenges we're facing and the threats to the international legal order, I hope you'll forgive me for seeing something positive in the four papers we're about to hear. And I think that's even if our speakers will quite rightly be helping us see where the challenges lie in some of the new and emerging areas of international law that we all need to be thinking about. These papers will cover a wide range of topics, from space law to AI and individual criminal responsibility, as well as pathogen access and benefit sharing in light of the new pandemic treaty. But what unites all of them is that they demonstrate the ability of international law to adapt to change, as well as the risks we face if it does not keep up. Whether we're thinking about the rise of the private sector in space or killer robots or the approach the world is going to take to sharing pathogens, we have a responsibility to be thinking about whether we can do more to ensure the international legal framework in place is fit for purpose. And we're lucky to be joined today by people who've already started working on that task. So on that note, our first speaker this afternoon is Paulina Rundel, who is currently a PhD candidate in climate litigation and human rights and a researcher in the International Law Department of the University of Vienna. She has previously supported the work of the International Law Commission in its study on the settlement of international disputes in the context of international organizations and many other topics. And her paper today is on the Moon Agreement and the Artemis Accords.
Good afternoon, everyone, and thank you for this kind introduction. Since this topic or this panel focuses on legal innovations and new developments in the area of international law, there's one area that should be addressed, and that's space law. So me and a colleague of mine are actually going to talk about space law today. When we think of it as two different, like when we look at space in general and then have a focus on the Moon Agreement, there is actually two important legal frameworks that we have to look at. One is the Moon Agreement, which is really in the UN framework. And then there's also more US-led, the Artemis Accords. And we see a challenge there with the UN Charter, with the UN framework, because it is something that's outside the UN as such. While both reflect a vision to the lunar governance, one is more rooted in the collective multilateral sphere, and the other one is really more on national discretion and commercial interest. And these are like why there is this challenge that we are here to talk about at this annual conference today. The debate about the lunar governments really comes from the whole program of NASA at the moment, from the Artemis program. And it is a very ambitious effort that was actually supposed to, after 50 years after the last time a man was on the moon, this was supposed to be the year 2024, actually last year, the year where the first time a woman and also a person of color should be first on the moon. However, with the Trump administration and SpaceX and Elon Musk, there has been a lot of tension, and that goal has actually been retracted from the Artemis program. Perhaps Ms. Vitoloni will talk about this today as well, because she's more focusing on the private parties issues in that sense. I'm here to focus on the two conflicting frameworks of the lunar governance and how this actually has a challenge to the international framework. Just to guide you through a little bit, first I will outline how space law in general is governed by the UN Charter principles, and then I will compare the Moon Agreement and the Artemis Accords. I'll also introduce space law in general a little bit, just for those of you who haven't really been in contact with this area of international law yet. And finally, I will explore the challenges we actually face today in the international governance sector, and then how we could possibly look at it in the future. So space law is really something where we have to think more of a very specific niche topic of international law, which has developed quite a bit. However, when we think of it, it's not really the law of tomorrow. It could also be called the law of today or even from the past, because actually the 5 treaties that are the most important ones from the UN framework for space have actually been developed in the late 1960s to the late 1970s. And those are the Outer Space Treaty, the Rescue Agreement, the Liability Convention, and the Registration Convention, and lastly, the Moon Agreement, the one that I'm focusing on in this paper. The UN is actually working through the UNOSA with this, so the United Nations Office of Outer Space Affairs, which is situated in Vienna, and this is where my experience comes in. And there is the COPUS, the Committee on the Peaceful Uses of Outer Space, which has a legal subcommittee and a scientific technical subcommittee. So you really see there is this disciplinary approach between science and international law in this regard. And just like Judge Thomas Halter, for example, really emphasized on the importance of science in international law, you see it in space law perfectly. When we look at space law, we also see a lot of the foundational international legal principles that can be found anywhere when we look at the 5 treaties that govern space law so far. And we really have, for example, the prohibition of the use of force. We have sovereign equality of all states, and also the promotion of peaceful multilateral cooperation as such. And they really did shape legal governance in outer space so far. We also have the Magna Carta, you could say, of space law, which is the Outer Space Treaty, the first one that was established. And it actually emphasizes that space is supposed to be the province of all mankind. In Article 3, it also really makes this connection to international law, that it should always be governed by it, and also references the UN Charter. So here you see also the context to this year's conference topic as well. The Moon Agreement then actually goes even further than just looking at it as a space of humankind, but also implements a broader principle that you might know from the law of the sea. So we're looking kind of to what we have discussed yesterday as well with the law of the sea, and that's the common heritage of mankind. This is also very much led here in the Moon Agreement. It was adopted in 1979. It was actually the latest of the 5 treaties of the UN. And when we look at it in Article 11, we have this common heritage of humankind principle in there. And it really envisions a regime where we manage the exploration and the use of lunar governance and the resources for the benefit of all, especially developing countries as well. And it is really important to mention here as well that Article 2 also references international law and the UN Charter. And this is really where the main focus point of this topic is that I'm exploring, since this is the issue with the Artemis Accords, which I will come to in a minute. The issue of the Moon Agreement is that it didn't have a lot of ratifications, and there are especially none of the major space powers that are supporting the Moon Agreement so far, especially the United States, back then the Soviet Union, and also later China rejected the agreement. They were really of the opinion that it was too restrictive and limiting their ability to extract and exploit the resources of the moon. And this probably highlights it best. You can see not a lot of ratifications have been done so far. It's only 17 state parties. Saudi Arabia actually withdraw in 2023 when they actually signed the Artemis Accords because they felt there was a conflict. Australia, for example, was the first one where there was actually this big legal scholarly debate whether it can sign the Moon Agreement back then and also sign the Artemis Accords, because it did. So there's this dual tension when it comes to the ratification. And coming to the Artemis Accords, in contrast to the Moon Agreement, the Artemis Accords really represent a very different vision of lunar governance. It was actually launched by the US in 2020 with 7 other signatories: Australia, Canada, Italy, Japan, Luxembourg, and the United Arab Emirates and the UK. And this was really a more political framework. So that's also very important in this sense, is that it's non-binding and also not registered under Article 102 of the UN Charter. And this really falls outside the UN or international legal treaty law that we know as traditional. And this is where you see the shift from multilateralism to bilateralism. And this is really the biggest challenge of it. And it does also not reflect any existing custom or emerging customary international law, but rather it sets obligation to the signatory states, which are then supposed to sign bilaterally agreements. And by rather using the international forum that the UN has established, it is really US driven in a sense, and this has also gathered a lot of critique. It does have a lot of flexibility and also emphasizes on national authorization of space activities. It has a bigger focus on commercializing space and also to extract and utilize lunar resources. And this is really where this conflict between the Artemis Accords and the Moon Agreement come in. Because unlike the Moon Agreement, this is really permitting individual states to extract any resources from the moon. It is said that because it's so driven by the US instead of COPUS, for example, from the UN, that it also really reflects those interpretations, especially when it comes to non-appropriation. So here we have the interpretation of the US that it actually, Article 2 of the Outer Space Treaty, for example, does prohibit national appropriation as such, but that the US is in the interpretation that the ban does not extend to the extraction of the moon or any lunar resources themselves. And under US law, this says that one may not claim the moon as such, but one may own what is extracted or mined from it. And legal scholars, for example, also Frans van der Dunk, contends that the US is with this actually using the accords to gather consensus for its own interpretations of space law, which do not align with the ones that were established by the UN back then. And this interpretation really has also provoked a lot of criticism regarding the unilateralism and also the bilateralism. It's also undermining the common heritage of mankind principle that is so engraved in the Moon Agreement. And this is really something where you can see this geopolitical shift from from multilateralism to this national discretion and commercial engagement, which of course is also in a world as today a bit understandable that you want to be in the space race as well as a state. However, it is bringing it back to multilateralism and the UN framework as such. You can see here that there have been a lot of ratifications. Today, in total, 53 nations are signatories, including major spacefaring nations as well, especially, of course, the US, but also Japan, India, and the UK and Australia. And in fact, in 2024, just last year, 19 actually added to this. So they added to the Artemis Accords as well. So there has been a lot of shift in the last few years and a lot of signatories. And meanwhile, you can see it with comparison to the Moon Agreement, how there is this proper shift on it, as I said before. And when we look at the key differences for one more time, we really also see how the private sector role is also encouraged, which might be talked about later as well in this panel. And we have this proper move from multilateral to bilateralism as well. Here you can also see this contrast again, which is just also to show you how there is this shift really where the US has led more than the UN as such. And when we look at the challenges in general as well, we have not only this shift from binding treaties to non-binding treaties, because there has been a lot of soft law and instruments used in space law so far. There have been some ideas to also reform or also have other, for example, for the non-weaponization of space, there has been a lot of ideas to also make hard law, but as we also heard today, there is a lot of soft law going on, and it's sometimes easier, especially in something where it's so technical and so evolving all the time. There are a lot of concerns that have arisen, especially when it comes to legal fragmentation, also the resource disputes. We have a shift away from the non-appropriation principle and also from multilateralism, as I said. There have been a lot of emergences to also de facto territorial zones on the moon and also safety zones provisions. So there has been a lot moving backwards to the Moon Agreement's ideas, or also the COPUS ideas that have been discussed. And then, of course, also the dual membership issue is also still something that been discussing for a long time already as well. And while space governance continues to uphold the spirit of the UN Charter, especially in the past, there is still this question if it's still based on this today. So, of course, we also have to look ahead and not just look at the problems and the challenges. So there has been a lot of debate about how we could actually move the space talk again, not to the sovereignty of states and the national interest, but rather to the international forum again. We have different ideas for this at the international legal bubble, you could say. One is, of course, very idealistic, which is always reforming existing treaties, such as the Outer Space Treaty, for example, or the Moon Agreement. It could modernize space law and account more to commercial mining and private sector roles, and also the evolving technologies realities that we have today. However, there's, of course, also a lot of realities when it comes to COPUS and how the work is done there with all the annual conferences and how fast this would also evolve. There are ideas of a hybrid reform, like so for example, there could be an emergence of combining soft law flexibility and hard law as such, to also preserve the fairness, transparency, and equity and accountability. Especially since the Artemis Accords, for example, have also some positive aspects as well that are very beneficial. For example, the recommendations to non-interference. We have the release of scientific data and also the protection of the environment regarding, for example, long-term sustainability guidelines on space debris. There has been a lot that could be used as well. And then, of course, also the role of COPUS could be improved, because especially this would be very crucial to have one UN body still to be the main part and not to have states actually turn their backs on the UN body as such. And this could also be helpful to coordinate soft law instruments and revive the efforts of binding agreements. Some scholars also suggest more engaging the ILC in this as well, which could also play a role. Here, we could probably turn back to what was said yesterday by His Excellency Judge Aurescu, who mentioned that it is important to first approach the states in the Sixth Committee in New York and really see their willingness to discuss this and also how this could be implemented into the ILC's work. And at the same time, regional initiatives are happening at the moment as well. Of course, there is, for example, the European Space Agency, ESA, but also the African Space Agency that was implemented last week. So there is a lot of movement, and there's still this attempt to really go into more inclusive governance that can also be more steering back to multilateralism. And to conclude, so we have this whole discussion about multilateralism and bilateralism that's perfectly illustrated by the Moon Agreement and the Artemis Accords, and especially this move away from the International Law Forum as such. But it actually doesn't just doesn't just illustrate that it's just two different legal frameworks that can be used, but rather a broader struggle as such as well. When we look at traditional multilateralism and bilateralism, or like a more decentralized model that is steered by one of the major states as such. And of course, UN Charter's principles, as this annual conference topic is about, really have to still remain relevant and are relevant. However, there needs to be a refocus to remind everyone as well, again, to really keep them in mind. And how we govern the moon today isn't just about whether this will have the legal architecture of space law preserved, but rather it's also about the broader values of international law. And this is why this maybe rather new topic can also help to form this kind of debate as well, and shows how there are these challenges to international law that we have to tackle as such. Thank you very much for your attention, and I'm looking forward to questions.
So while the slides are being pulled up, but I don't think you have any slides for you, or no? Okay. Yeah. So our second speaker then is Dr. Abbie-Rose Hampton. Abbie completed a PhD at King's College London and specialises in international law and infectious diseases, looking at how existing frameworks can be improved to achieve global health justice. And her paper today is focused on pathogen access and benefit sharing.
Thank you very much. Good afternoon, everyone. So, COVID-19 emphasised the importance of global cooperation, timely sharing of pathogen samples, and the need to deliver equity, fairness, and justice in pandemic response. These issues have been central to the negotiations of the pandemic treaty at the World Health Organization. The treaty seeks to overcome many of the flaws in the international COVID-19 response, including the rampant vaccine nationalism and hoarding of other medical countermeasures by high-income countries. And what has been described as a win for multilateralism, after more than 3 years, treaty negotiations came to an end on the 16th of April 2025, with consensus having finally been reached on the text, which is to be presented for consideration at the upcoming World Health Assembly in May. In getting to this point, the countries of the world have demonstrated their shared commitment to preventing and protecting everyone from future pandemic threats. But despite its best intentions, I contend that the pandemic treaty is at risk of doing little more than maintaining the status quo with regards to facilitating access to vaccines and other medical countermeasures during the next health emergency. This is a direct consequence of the highly contentious Article 12, which functions to establish a new multilateral access and benefit sharing system for pathogens with pandemic potential. The WHO Pathogen Access and Benefit Sharing System, or the PAB system as it is more commonly known, with the key concern here being the continued use and further entrenchment of access and benefit sharing, or ABS, within the global health landscape. As a starting point here, it's going to be useful to offer a brief introduction to ABS and its role within the global health landscape. So, international law regulates how genetic resources, including pathogen samples, are to be accessed and shared between countries, and how the benefits derived from their utilisation are to be subsequently shared. This is achieved via ABS, a transactional mechanism which was designed to allow and encourage countries to trade their sovereign genetic resources, such as pathogen samples, in exchange for access to monetary and non-monetary benefits derived from their use in research and development, such as vaccine. Countries are therefore free to trade, or indeed not trade, their pathogens. For many low-income nations, however, engagement with ABS is considered an essential and perhaps even the only means of securing access to life-saving vaccines during a health emergency. Despite finding its origins in the negotiations for the Convention on Biological Diversity as a market-based and competition-orientated approach to combating biopiracy and assuring the conservation of biodiversity, ABS was extended into pathogen sharing following the first explicit framing of access to pathogen samples in exchange for benefits by Indonesia in 2006. This followed their decision to withhold access to samples of H5N1 viruses which had been collected within their territorial borders, choosing instead to cite the CBD and assert sovereignty over the samples, a decision which was a direct response to the exploitative and inequitable system of pathogen sharing which existed prior to ABS being transposed into global health. This framing, alongside recognition of the inequities and injustices experienced by LMICs, ultimately culminated in the adoption of the WHO's Pandemic Influenza Preparedness Framework, otherwise referred to as the PIP framework, and the creation of a multilateral ABS system for influenza samples with human pandemic potential, marking the formal transition of ABS into the global health landscape. The role of ABS within the global health landscape is set to be extended further via the Pandemic Treaty, with the PAB system set to apply to all pathogens with pandemic potential, as well as associated genetic sequence data, something which is not included within the PIP framework. As part of this, in the final compromise, manufacturers committed to donating 10% of their production to distribute by WHO, with a target of offering another 10% at affordable prices. The details of the PAB system still need to be worked out in an annex, with negotiations set to occur over the next 12 months. Now, the argument which I present here today, and which my colleagues and I have detailed elsewhere on numerous occasions in recent years, is that the extension and further entrenchment of ABS within the global health landscape in the form of the PAB system will do little more than maintain the inequitable status quo by virtue of the inability of transactional ABS mechanisms to deliver anything remotely close to fairness, equity, or justice. Despite appearing to rectify the historical wrong of rampant biopiracy by the global north, the current system for sharing pathogens and associated medicines for pandemic preparedness and response does not work. Whilst the development of the mechanism may have been grounded in the pursuit of equity and justice, ABS has clearly flawed on a number of levels. It has fostered an environment where countries can withhold pathogen samples and associated data, threatening the ability to develop up-to-date vaccines and medication, and producing fundamentally anti-scientific outcomes where, for example, vaccines have been developed using suboptimal pathogen strains. It has failed to deliver benefits at the levels required, both in the context of global health and its origins in biodiversity conservation, and has failed to alter the status quo in the context of providing access to vaccines. High-income nations maintain a monopoly over the ability to respond rapidly to infectious disease outbreaks by manufacturing vaccines. It is representative of the commercialisation and commodification of the ecosystem, and ultimately, ABS has become a legal compliance mechanism to justify a business-as-usual approach without fundamentally shifting power relations or economic disparities. The popular view that ABS is synonymous with equity is particularly troublesome. After all, can access to vaccines and other medical countermeasures via an ABS agreement be understood as delivering true equity, as delivering true equitable access to LMICs if it has to be purchased, bartered, or traded for? When it comes down to it, ABS is still just asking LMICs to trust that HICs will do what is right, that they will release vaccines and medical countermeasures during the next pandemic. It doesn't actually change the fact that the overwhelming majority of manufacturing capacity for pandemic-related products is limited to a small number of HICs, nor does it change the dependency-based model of global health, with LMICs remaining dependent on the goodness or the kindness of HICs. If it works, and that is a very big if, given the many good reasons to believe that it will not, the best case scenario is that it will make sure that a small proportion of vaccines end up where they need to be, and the rest will continue to go to the highest bidder. Although the Pandemic Treaty appears to be an ambitious effort to rectify global inequalities and inequities, this research contends that the expansion of ABS within the global health landscape will not facilitate the meaningful change which is required to turn rhetoric into reality. I therefore advocate for a move away from the continued reliance on transactional ABS approaches within global health to facilitate the introduction of alternative approaches which are truly capable of delivering equitable outcomes. However, I also recognise the barriers to change presented by path dependency. with the narrative that ABS is synonymous with equity, that it is capable of decolonising global health, and that it is the best solution to the problems which it is seeking to solve, having become so deeply embedded and embraced within global health that it has become increasingly difficult to return to a time where multiple alternatives were available, something which has become increasingly apparent over the course of treaty negotiations. Despite this, I favour a complete delinking of the access and benefit sharing aspects of the ABS transaction, with access to pathogen samples no longer being contingent upon access to benefits and vice versa, provided that viable solutions to each aspect are developed and implemented simultaneously. In devising these alternative solutions, I recognise that in order to facilitate the support and engagement of all relevant stakeholders, that it is essential that the following 2 points form the foundations of the development process. First, being that solutions are found to both components, the access and the benefit sharing, ensuring that one is not given priority over the other. And two, that beyond ensuring that alternative solutions are found to both aspects, that those solutions are then implemented simultaneously, as failure to do so would be the removal of the one bargaining chip that LMICs currently have in order to secure access to vaccines, and would simply perpetuate and reproduce the inequities and injustices which this research is trying to overcome. In my work thus far, I have favoured commons-based approaches or commons-based alternatives to the reliance on ABS within global health, advocating for a move away from the international law which governs and promotes ABS towards a more meaningful, regionalised approach in the pursuit of equity, fairness and justice, namely through the sharing of the research, technology and know-how which will facilitate the development of manufacturing capacity in LMICs. With regards to the access component of the ABS transaction, I support the development and implementation of a commons-based approach to pathogen sharing, with this requiring recognition that pathogens form part of the global commons as either the common heritage of mankind or the shared responsibility of the global community. In devising an alternative to the benefit sharing aspect of the ABS transaction, I present a number of criteria which the developers of any such alternative must consider and utilise as the foundations upon which a new solution can be built. The first being that a move away from ABS and global health should not mark a move towards charity, and the second being that such a solution must be localised in nature, marking a move away from the centralised pooling based around the WHO, which has typically been favoured, both in the context of multilateral ABS and multilateral charitable approaches. It follows that I propose that an alternative solution to the benefit sharing aspect of the ABS transaction should focus on ensuring that LMICs are capable of self-procuring vaccines and other medical countermeasures during a health emergency by increasing global manufacturing capacity within LMICs themselves. This is by no means a radical or particularly novel suggestion, but there having been several initiatives and partnerships which have occurred over the years which have sought to improve manufacturing capacity within LMICs. In order to increase manufacturing capacity, LMICs require access to knowledge, technology and information, which is neither freely nor readily available at present, with much of this being protected by the regime under the TRIPS agreement, where IP is treated as sacrosanct even in times of emergency. Now, this is perhaps where the more radical aspect of my solution comes to play, as I propose that the knowledge and information which is required to increase manufacturing capacity should be made freely available in a commons-based system, such as that proposed by this research for pathogen sharing, a solution which I can guarantee will not go down very well with many. But increasing manufacturing capacity and ensuring access to medical countermeasures for LMICs in such a way would go beyond the ABS transaction, beyond the structural inequalities which plague the global health landscape, towards the global rebalancing of access to both knowledge and medical countermeasures, whilst affording the necessary priority to notions of solidarity, community and justice in the process. To conclude, the expansion and continued promotion of ABS within global health via the pandemic treaty would amount to a missed opportunity in international law and a gross failure in the pursuit of equity and justice. Ultimately, it is time to mark a move away from international law which maintains and reproduces the current world order, the power asymmetries which exist between HICs and LMICs, towards international law which is grounded in what we want to see reflected in the world: fairness, equity and justice for all, and is capable of facilitating the meaningful change required to turn the utopian dream into reality. Whilst a new PABS mechanism under the pandemic treaty feeds into the former, the solutions proposed here today seek to fulfil the latter. Thank you very much.
So our third speaker now is Milena Sterio, who is a distinguished academic specializing in, among other things, international criminal law and human rights law, and a managing director of the Public International Law and Policy Group. I hope she won't be surprised to hear this, but I've had the pleasure of reading much of her work over the years, and it's a privilege now to be able to introduce her as a speaker. Her paper concerns artificial intelligence and individual criminal responsibility.
Thank you. Thank you so much for the kind introduction. Thank you to the editors of the journal for convening this lovely conference. And in particular, thank you to all of you for staying with us on such a lovely day. I'm sure that at the end of 2 very rich days of conferencing, you're ready to have a pint by the river. And I very much appreciate your willingness to stay with us until the end. My paper is about the use of autonomous weapon systems, in particular situations where autonomous weapon systems rely on artificial intelligence, but because of an error committed by artificial intelligence, the weapon system commits an error which results in significant harm and sometimes lethal harm. And I would argue that this paper fits particularly well within the theme of the conference, which is about post-World War II challenges to our existing international legal order. This is definitely an area where we're facing challenges, where, as I will argue, we do need either new rules or a new understanding of how to conceptualize crimes. And so my paper in particular talks about implications of all of this on international criminal law. And as I will argue, existing modes of liability and existing mens rea within international criminal law fail to impose individual criminal responsibility on humans who are implicated in the operation of autonomous weapon systems using artificial intelligence. Now, a short parenthesis here to mention that there have been significant academic, policy, legal, interstate debates on the use of autonomous weapons, but that most of those debates have centered either around the definition of autonomous weapon systems, because those of you who work in this area will know that the very definition is controversial, and then also have centered around either the need to prohibit them altogether or the need to regulate them in a way to ensure that their use is consistent with international humanitarian law. But relatively few debates have taken place thus far about the rules of attribution. And so let me start with a hypothetical. We in the United States law professors, we talk in hypothetical, so bear with me. Imagine an autonomous weapon system which relies on artificial intelligence for example, facial recognition. And imagine that the facial recognition fails, and instead of selecting the combatant who would have been the legitimate target of an operation, the facial recognition system selects the person's identical twin. Now, for those of you who are twins here, apologies for the horrible hypothetical. I'm an identical twin myself. I'm the mother of identical twins, and so I feel particularly entitled to pick on twins. But imagine a situation where this happens. The strike is definitely illegal under international humanitarian law because the target is a civilian. The target is the good twin. However, under the regular rules of international criminal law, the humans who are involved with the operation of the system, the weapon system, be it the weapons designer, the tech person, the weapons operator, or the operator's commander, and these are typically either military or intelligence officers, cannot incur individual criminal responsibility because they do not possess the requisite mens rea. So we know that under international criminal law, and let me just quote the Rome Statute as reflecting customary law. So for example, Article 25 of the Rome Statute criminalizes different forms of commission, criminalizes direct perpetration, co-perpetration, as well as indirect perpetration or co-perpetration, such as, for example, ordering, aiding and abetting, contributing, facilitating an attempt. However, for all of these crimes that are within the Rome Statute, that are within customary law, typically the mens rea that's going to be required is either knowledge or intent. And I would argue that within my hypothetical, the weapons developer or the weapons operator or the operator's commander simply do not possess the knowledge or the intent that the wrong target will be involved, that the weapon will strike an illegal target. The weapons manufacturer or the weapons designer typically designs the weapon in a way where they're using the requisite standard of care and in a way where they believe that the weapon will appropriately select the target. And then the weapons operator and the operator's commander also operate the weapon or order the commission of the attack in a way where they believe that the attack will be committed appropriately using the right terminology and that this will result in the selection of the correct target. And so none of those individuals have the knowledge or the intent, which would be the mens rea requisite for the commission of these international crimes. Now, allow me just another brief parenthesis here to exclude a few discussions from the scope of my paper. So some scholars, for example, have advocated towards the need to empower AI systems with legal personality, to conceive of AI systems as a legal entity that can then incur criminal responsibility. I don't express any thoughts or conclusions regarding this argument. It simply goes beyond the scope of my paper. I'm concerned with international criminal law, which in its traditional iteration is concerned with imposing individual criminal responsibility on humans. And let me exclude another argument that maybe has some value, but again goes beyond the scope of my paper. Some have argued that a potential avenue for the criminal responsibility of the programmer or the operator would be to individualize the obligation that's enshrined in Article 36 of the first protocol to the Geneva Conventions, which imposes an obligation on states to study new weapons and to make sure that any new weapons that are used are consistent with their obligations under the Geneva Conventions. And so some have said you can sort of individualize this obligation in order to be able to criminally reach the behavior of a programmer or an operator. Another interesting argument that goes beyond the scope of my paper. My paper instead focuses on a way to reconceptualize existing crimes to perhaps include lesser mens rea in order to be able to impose individual criminal responsibility on the weapons designer, weapons manufacturer, or then the weapons operator or their commander. There are two possible mens rea that I discuss in my paper. One is criminal negligence, and then the other is strict liability. So first, let me start with criminal negligence. Criminal negligence is a relatively well-established mens rea in Anglo-American law. Here, we're talking about a person who acts negligently when they should be aware of a substantial and unjustifiable risk that their conduct will result in a material element of the offense, and the risk here must be such that the actor's failure to perceive it as is a gross deviation from the standard of care that a reasonable person would observe in the actor's situation. And so here we're talking about a situation where the actor is not blamed for their culpable state of mind, but instead they're blamed for their failure to live up to the standards of this fictional reasonable person. And to the law students in the room, I remember when I began my law studies more than 20 years ago, when I first heard of this concept of a reasonable person, I was like dying to meet the reasonable person. And trust me, they don't exist. It's a fiction. It's a legal fiction. And yet for purposes of criminal negligence, we talk about the standard of care that a reasonable person would have. Now, this model of liability could work because we're talking about a lesser mens rea than knowledge and intent. There are some issues with it, and I go into more detail about this in my paper, because it is possible to argue that so long as the weapon is developed pursuant to a standard of care of a reasonable person, and so long as a weapon is utilized in a way that coincides with the standard of care of a reasonable person, the weapons manufacturer, designer, or the operator / commander would not even be guilty under this standard of criminal negligence. Yet a rebuttal to this would be to say that it is possible to conceive of this more broadly, to interpret all of this more broadly, to say that basically using an autonomous weapon system which relies on artificial intelligence always poses a substantial risk that the conduct will result in an offense, that this is entirely foreseeable. So it is possible to at least discuss the possibility of using this criminal negligence standard. Now, another possible model that's even harsher, if you will, is strict liability, another well-established concept in Anglo-American law, something that's very heavily utilized in American tort law, which is obviously civil law, not criminal law, yet I'm drawing a parallel in this context. So strict liability stands for the proposition that for inherently dangerous activities, the law does not and should not look at how effectively one observes their duty of care, their standard of care, that instead, when those very dangerous acts are being performed, and if there's harm resulting from the performance of such dangerous acts, the actor is simply going to be on the hook for that harm, irrespective of their level of care. And so here, scholars have already, and particularly one scholar, has already advocated in favor of adopting this type of a strict liability approach within the context of the crime of aggression. So when we have cyber attacks that amount to aggression, and we're talking about AI-powered cyber attacks, this scholar has already argued that we should reconceive of the crime of aggression to adopt this mode of liability in this lesser mens rea of strict liability, because we're talking about an ultra hazardous, ultra dangerous activity such as the use of autonomous weapons using AI, and that we should simply not care about the standard of care that's adopted by humans who are associated with the usage of these systems. And so in this paper, I dig a little bit deeper into this. And so borrowing factors from US tort law, here in this paradigm, a judge trying to impose individual criminal responsibility on someone using strict liability would have to look at three factors. First, the risk that the harm resulting from the attack will be great, which I here would argue it definitely would be. Two, the defendant's inability to eliminate risk through the exercise of reasonable care. And then third, the extent to which the activity is not a matter of common usage. And I would argue that this third criterion is also fairly easily satisfied. We are not talking about common usage. Where we run into a little bit more difficulties, the second factor, the defendant's inability to eliminate risk. There, we run into some of the same issues as when we talk about criminal negligence. And so just to conclude here, and let me use the remaining few minutes to just push back against some possible counter arguments to my own argument. So first, some might argue that this is simply not necessary, that the reason that international criminal law does not work here is that it's because it should not work, because we're talking about holding somebody responsible when they don't have the requisite mens rea of intent or knowledge. I would push back against that argument from the point of view of justifications of criminal punishment. I'm sure most of you are aware of various theories of criminal punishment, such as retribution or deterrence. I'm not a retributivist myself, so I always hesitate when I rely on retribution. But for the purposes of just this argument, I would argue that there is something deeply morally unsatisfactory about the fact that you can have lethal attacks and yet no individual criminal responsibility, even though humans are involved on some level, and that from both a retribution and a deterrence standpoint, there's again something deeply wrong with saying, well, no human is responsible. The second counter argument that I would address here is some would say, well, this goes beyond the purview of international criminal law. This is simply an issue that should be left to domestic law. And I wanted to push back against this for several reasons. Well, first, we know from experience that when domestic criminal systems are charged with investigating potential violations of the law of armed conflict, it typically results in zero accountability. So let me mention two examples from the United States and also here from the United Kingdom, because we are here. But we know that, for example, in the United States, there were significant abuses committed by the US military and military contractors at Abu Ghraib, which have resulted in literally zero accountability for anyone involved. And we know that UK forces have been accused of serious wrongdoings in Iraq, and yet despite a commission of inquiry, to the best of my knowledge, there have been zero prosecutions at the domestic level. And so I just bring those two examples. There are definitely others. And so typically when we're left with domestic systems investigating and prosecuting themselves in their own intelligence or military, I would argue that it typically results in very little accountability. But perhaps the more important counterargument here is to talk about the expressive value of international criminal law. And other scholars have talked about this a lot as a general matter. But basically, international criminal law has sort of more value than domestic laws because of its own inherent expressive value. And that when we forget about international criminal law and say, no, 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 this is the purview of domestic law, that expressive function of international criminal law simply does not work. And so for those reasons, especially because we're talking about a new area of the law, we're talking about an area where accountability is needed, I would argue that there are lots of reasons relying on the expressive value of international criminal law to say that there is a need to reconceive of international criminal law and reconceive these international crimes. And then last, I would say that because we're talking about this very new area of the law, there is a need to actually develop international criminal law so that it better corresponds to the realities on the ground. Despite serious criticisms of autonomous weapon systems, I hope that everybody in this room realizes that they're here to stay. They're very popular with militaries across the world. They're not going anywhere. We can sort of pretend and say, oh, they're a bad thing. They're here to stay. So I think at best we can try to regulate them, and at best we can try to impose criminal responsibility on those who use systems when there are lethal errors as a result of the usage of these systems. And so I would argue that there's a particular need here to develop new rules of international criminal law to be able to capture this idea of individual criminal responsibility in an area where we're in a situation where the usage of these weapons will just continue to grow. And so we can sort of pretend that it's not an issue. We can pretend that we can ban these weapons, but that's just simply not the reality. And so to conclude on this theme of challenges to our post-World War II legal order, we're in an area we're facing challenges. I do think that there's an opportunity to reconceive of existing rules so that they better correspond to the reality on the ground. Thank you.
Okay, thank you very much for that. So our fourth and final speaker is Martina Vitoloni of the McGill Institute of Air and Space Law. And Martina is an emerging expert on space law issues and is increasingly being called upon in international fora to express a view on the adequacy of the existing framework as it relates to issues of international responsibility for space activities. Her paper today is titled Orbiting Beyond Control, International Law and the Rise of Private Power in Outer Space.
Thank you everyone for staying and so late. I promise to not go over time because I will also like to be by the river with a pen. So I will keep talking about today about responsibility and about space. I will particularly focus on responsibility for private actors in space, but approaching this from a theory of state responsibility, particularly through attribution. So as we know, attribution is an essential element of the theory of state responsibility. Without attribution, we will not have international responsibility. And at the international level, we can see that the rule is that private actors, their conduct is not attributed to the states, with the exception being when that conduct is under the instructions, direction, or control of the state, in other words, under the effective control. So here there's supposed to be a slide, okay. We find the rule of effective control in different sources on international law, particularly ICJ cases, Nicaragua, armed activities in Congo, Bosnian genocide. Then ILC picks up this rule of effective control and codifies it in Article 8 of RCWA. And whereas the case law, we can see that it's mostly related to guerrillas or paramilitary groups, ILC is very clear in the commentary when it says that when we are talking about corporations, the fact that it's a state-owned company or a state-controlled company is still insufficient to establish that there is effective control over that company, and therefore the conducts of the company are not attributed to the state. So this brings me to the question, why should we care about the attribution of private actors in space? And I think that picture speaks better than words sometimes. This is a map with every single Starlink satellite. As of today, it's 7,135. The FCC authorized Starlink to launch 11,400 satellites. So imagine this picture with 4,300 more satellites. And you can see how this is only Starlink. Now you have to add other companies, the satellites of other states. And to put the number of satellites that Starlink have into perspective, Russia is estimated to have 1,500 satellites. Then we have France, who also registers all the European Space Agency satellites, and it is around between 500 to 700 satellites. So the number of Starlink, we can see that is very high compared to these other states who are also leading space actors. We also have other private actors because, of course, we always have their Jeff Bezos and Elon Musk because they're just everywhere. So we have Amazon launching the Kuiper project. They launched the first batch of satellites yesterday, 27 satellites out of 6,000 satellites that they will be launching. And we can see as well how Elon Musk saved the astronauts that were stranded in the International Space Station. So we're seeing a real increase on the presence of private actors in the space sector. And this makes us question, why should we use the rules of state responsibility for attribution? And I think that the court was very clear in Bosnian genocide when it says we should use these rules of attribution, except if there's a lex specialis rule that applies to this case. And this is the case with the Outer Space Treaty, Article 6, which in my opinion is quite clear when it says that states bear international responsibility for their national space activities, even when they're conducted by non-governmental entities. So here we have the debate between Article 6 of the Outer Space Treaty and Article 8 RCWA. While Article 8 RCWA establishes a standard that is quite stringent, I think the best example of this is Nicaragua, where the US was providing logical support, material, weapons. It was training the Contras, it was selecting their leaders, the military targets, and yet that still was insufficient to establish attribution to the United States for all the breaches of international law of the Contras. Whereas the Outer Space Treaty, it's a much more easy standard to meet. You just need to qualify an activity as the national space activity of the state. And that can be done through different standards. One of them can be the place of incorporation of the company. It can also be the state who authorized that particular operation. And at the same time, one operation can be fractioned. So for example, a state can be responsible for the launch, but not for the operation in orbit. And there's nothing in the Outer Space Treaty that prohibits more than one state to be responsible. So I think the question here is why I'm talking about this if the Outer Space Treaty is quite clear on this and this should not be a problem. Well, in this past year particularly, we have seen certain voices rising against this idea of Article 6 being a lex specialis rule of attribution. And there are some authors that are out there arguing how we should actually use Article 8 of RCWA and establish effective control because that's the right standard. And that should not have been a problem, but now it has become a real issue when we start hearing voices of very prominent space scholars who are not only scholars, but also are part of the delegations at UN COPIOS, who start voicing these ideas that private actors should not be attributed to states. So I want to show you today why not this argument is incorrect, but also very, very dangerous. So starting on why it's incorrect, I think when you have a doubt in international law, you just have to do a treaty interpretation analysis. Based on the ordinary meaning, we can see that Article 6 is quite clear. It establishes international responsibility, including private space actors. And back in 1967, state responsibility wasn't something new. ICJ had been operating for almost 2 decades. We had all the decisions of the PCIJ, claims commissions, and arbitration. And the rule was already that the conduct of private actors was not attributed to the state. So the fact that the states, during the drafting process of the Outer Space Treaty, decided to include this provision clearly shows that they knew that they were diverging from the existing rule of international law. And this is very well reflected on the writings of Manfred Lack, a former judge of ICJ, and he was the very first chair of the legal subcommittee of UN COPIOS. He was involved as well in the drafting of the Outer Space Treaty. And he writes how Article 6 leaves no doubt whatsoever with respect to the imputability of private actors to the state. You can also see what Bing Chen writes, where he's quite expressive, saying Article 6 is groundbreaking. We're going completely against international law, but this is the way that space should work. If we want to use another standard to interpret Article 6, we can also look at state practice. Since the Outer Space Treaty until now, we have almost 60 years. And if we look at the national legislation of states, we can see that many states incorporate the wording national space activities into their national legislations, which are destined to regulate how private space operators are supposed to operate. So one example is the Brazilian legislation, which was passed in August of last year. And they are very clear when they say this law only applies to the national space activities of Brazil. And then they start to enumerate a series of activities, among which we can find on-orbit servicing, space tourism, space resource exploitation as well. And then you have also other states like the UK, for example. In the UK Space Act, it indicates that the activities conducted by those UK space actors should be done in accordance with the UK international obligations. And now we have to think that private actors are not in itself a subject of international law. So the fact that a state is asking a private actor to comply with the international obligations of the state clearly shows that it is because that state believes that it can ultimately be held accountable because of those actions of the private state in itself. Further evidence of state practice, we can find it on case law, even if we don't have any real case law for space. We have some national cases that are very interesting to read if any of you is interested. One of them is in the US, in the Nemitz case, which was a private citizen claiming that he owned an asteroid and he was suing NASA. And the court was very clear when they say, we're not even going to entertain this claim because in the first place, it goes completely against international law, particularly Article 2 of the Aerospace Treaty. The other case that we have as an example is the Lunar Embassy case in China, where it's basically, for putting it lightly, it's a scam where you buy lunar property, but they actually only sell you a piece of paper. And the Chinese courts also recognize this, and they say this goes against China's obligation under the Aerospace Treaty, Article 2. So we see that through both the ordinary meaning and state practice results quite clear that this Article 6 attributes private actors to the state. But even if you have any doubt, we look to the preparatory works as well. There's one particular book that it took me forever to get hold of, and it's a person that is arguing Article 6 is not a lex specialis rule of attribution because this article was never discussed during the drafting of the Aerospace Treaty. And that argument is just not true. When you go and you actually read the preparatory works, Article 6 was a key point in the whole negotiation of the treaty. On one hand, we had the US, who wanted to allow the private operation of space activities without having any responsibility. And on the other hand, we had the USSR, who wanted only states engaging in space activities. Ultimately, the UK was the one to propose this compromise, which was we are going to allow private actors, but we're going to equate the conduct of private actors to the state. And that ended up on being what the Article 6 is nowadays. So this is my attempt to show you why this argument is incorrect. And I also want you to know why arguing this, especially in international forums, like some scholars are starting to do. We have an upcoming International Astronautical Congress, and there are many abstracts trying to argue that the conduct of private actors is not attributed to the states. And I particularly think that this is dangerous, and I don't think I really need to explain myself, but to express it in a manner, I don't think you need to think too much how wrong things will go if we give free ride to people like Elon Musk. So just imagine everything that can go wrong in space, which is a particular environment where if somewhere can particularly go wrong is in space. You have to consider the physics, the velocity at which the space objects are traveling, and you also need to consider that once you're up there, you're basically on your own. So giving free ride to space actors, to particularly private actors who have been driving space exploration, but they have always had this control check by the states. And we also need to consider the impact that this could have in societies day to day. So right now we are streaming on Zoom. For that, we need a satellite. For do any bank transaction, we need a satellite. Weather forecast, we need satellites. Even nuclear weapons are controlled by satellites. So we can see how much of our society depends in outer space. And this is why it's necessary for us to make sure that if things have to go okay, then states need to be involved in order to give this certain control of the power that we give to private actors and to not allow them to go beyond what it can be their own capacity or their own desire to conquer more of a space. This is a very fun fact that I always love to say. If you actually sign a contract with Starlink, you go to the very bottom of the terms and condition, and it says that you are accepting that there's no jurisdiction applicable on Mars, and that therefore Starlink and SpaceX on Mars are not under the US jurisdiction. So you can just imagine how wrong things like that can go once we start going to the moon and establish settlements and have people They just want to do their own activity without any regard to international law. And at the end of the day, one of the very basic principles of space law is the common interest. Space is supposed to be used in a manner that benefits all people of the world, all different countries, and we are all supposed to obtain a certain benefit. If we stop recognizing that private actors equate the conduct of the state, and therefore states are very likely to stop regulating and leave it to the forces of the market, then there is a huge threat that we are seeing here. So to conclude, I wanted to give you this very brief introduction to this problem that we are starting to see in this space community. And I really thought that doing it more in an public international law place will be more interesting than just in a space area, because we already know each other, we already know our own arguments. And I think this goes beyond state, because beyond space, because as I was mentioning, our daily life depend on space, and it's upon all of us, and especially legal scholars, to make sure that the international legal order for space operations keep work properly. So thank you very much, and I welcome your questions.